The meeting was set for May 10th at Mark's house, since he has the biggest dining room table. I showed up around 2 in the afternoon and immediately felt the weird energy when Lisa opened the door. She barely said hello and just pointed toward the dining room where Mark was already sitting with a bunch of paperwork spread out. I asked how everyone was holding up, and Mark just shrugged and said they needed to get through the business stuff first. Lisa sat down across from me and started tapping her nails on the table in this annoying rhythm. The lawyer hadn't arrived yet, but they seemed eager to start talking. Mark pulled out a legal pad with notes and said he'd been thinking about the most practical way to handle everything. He mentioned the rental properties would need management and the life insurance payouts were substantial. I was nodding along thinking this sounded reasonable when Lisa jumped in with her first bomb. She said they needed to discuss what to do about Jake and how his situation would affect the inheritance distribution. I asked what she meant by his situation, and she got this look on her face like I was being deliberately dense. She said everyone knew special needs kids were expensive and complicated, and maybe it would be better for everyone if we looked into other care options. I told her Jake was my son, and he was fine living with me, and I didn't understand what that had to do with our parents' estate. Mark cleared his throat and said they'd been talking and thought maybe residential care or foster placement might give Jake better resources than I could provide as a single parent. That's when it hit me what they were actually suggesting. I asked if they were seriously telling me to put my son in foster care, and Lisa said it wasn't that dramatic, just exploring options that might be better for his development. She said there were specialized facilities and programs that could help him more than I could. Mark nodded and added that it would also simplify the inheritance situation since I wouldn't have the extra financial burden of special needs care. He said they could help me research good programs and facilities in the area. The way he said it made it sound like they'd already been looking into this. I was getting angry but tried to stay calm and asked what exactly they meant about simplifying the inheritance situation. Lisa said that with Jake in proper care, I'd be free to make better financial decisions and wouldn't need to worry about setting aside money for his future needs. Mark said they'd been thinking about this since the funeral, and it just made sense from every angle. He said Jake would get professional care, I'd have less stress, and the family assets could be managed more efficiently. The way they talked about my son like he was some kind of financial liability made me sick. I told them Jake was staying with me, and that wasn't up for discussion. Lisa rolled her eyes and said I was being emotional and not thinking about what was best for Jake long-term. She said I couldn't possibly understand all the resources he'd need as he got older and that I was being selfish keeping him from better opportunities. Mark said they weren't trying to be harsh, but someone had to think practically about the situation. He said raising a special needs child alone while managing an inheritance was too much for anyone to handle effectively. The lawyer still hadn't shown up, and I was starting to wonder if they'd planned this conversation to happen before he arrived. I drove home that evening feeling completely shaken by what my siblings had suggested. The whole conversation kept replaying in my head, and I couldn't believe they'd actually told me to put Jake in foster care like it was some reasonable option we should consider. Jake was in the living room when I got home, building something elaborate with his Legos. He looked up and asked how the meeting went, and I told him it was just boring grown-up stuff about paperwork. But he's pretty perceptive and could tell something was wrong because he asked if I was sad about Grandma and Grandpa again. I sat down next to him and said I was just tired from the long day. He nodded and went back to his building project, but kept glancing at me like he was worried. Jake's always been sensitive to changes in mood and routine, and I didn't want him picking up on my stress about what Lisa and Mark had said. While Jake was getting ready for bed, I started thinking about my parents and how they'd react to hearing their other kids wanted to dump their grandson in foster care. My parents absolutely adored Jake and never once treated his autism like it was a problem to be solved. They learned about his needs and adapted their house and activities to include him in everything. After Jake was asleep, I called Mrs. Patterson to thank her for watching him and ended up telling her about the meeting. She was horrified when I explained what Mark and Lisa had suggested, and said she couldn't believe anyone would think that was appropriate. She reminded me that my parents had always been proud of how I was raising Jake and had mentioned multiple times how well he was doing. That's when I remembered something my dad had said a few months before the accident. He'd pulled me aside during Jake's birthday party and said he and my mom had been updating their will to make sure Jake would always be taken care of. At the time, I thought he just meant they were including Jake in their general estate planning, but now I was wondering if there was more to it. I went through the paperwork the lawyer had given me earlier and found a sealed envelope with my name on it. Inside was a letter from my parents dated just 2 months before they died. The letter explained that they'd set up a specific trust fund for Jake's future needs because they wanted to make sure he'd always have resources available regardless of what happened to me. The letter said they'd been watching how Mark and Lisa reacted to Jake's autism over the years and were concerned about their attitudes. My parents wrote that they trusted me completely to make decisions about Jake's care, but wanted to ensure he had financial security that couldn't be influenced by other family members. Reading that letter made me realize my parents had seen exactly what I'd witnessed at Mark's house that afternoon. They'd recognized that my siblings viewed Jake as a burden rather than a beloved grandson, and they'd taken steps to protect him. The trust fund was substantial enough to cover his needs for his entire life, including any special services or care he might need as an adult. I felt this mix of gratitude toward my parents and anger toward my siblings for proving exactly why the trust had been necessary. My parents had basically predicted this whole situation and made sure Jake would be protected from people who didn't value him the way they should. The next morning, I called the lawyer's office first thing and scheduled an individual meeting to discuss the trust fund my parents had set up for Jake. The lawyer, Mr. Henderson, said he could see me that afternoon and that he'd been expecting my call since the family meeting had been postponed when I'd left abruptly. I arranged for Jake to stay with Mrs. Patterson again and drove to Mr. Henderson's office downtown. His secretary showed me into a conference room where he had Jake's trust documents already laid out on the table. He said my parents had been very specific about their intentions and had actually updated the trust just weeks before their death. Mr. Henderson explained that the trust was irrevocable and specifically designated for Jake's care, education, and living expenses throughout his lifetime. The principal amount was around $400,000, plus Jake would inherit one of the rental properties when he turned 25. My parents had also included provisions for additional funding if Jake needed specialized care or services. I asked about my siblings' reaction when they learned about the trust, and Mr. Henderson said that's where things might get complicated. He explained that Mark and Lisa would likely contest the will once they understood how much of the estate was designated specifically for Jake. He said families often became hostile when they felt inheritance distributions were unfair, especially involving special needs beneficiaries. Mr. Henderson warned me that my siblings might try to argue that Jake couldn't manage the trust funds due to his autism, or that I was an unfit guardian who couldn't make appropriate decisions about the money. He said these kinds of challenges were unfortunately common when substantial assets were involved. I told him about the conversation at Mark's house and how they'd suggested putting Jake in foster care. Mr. Henderson looked concerned and said that kind of attitude toward Jake could become part of a legal challenge to his inheritance rights. He suggested I start documenting any interactions with my siblings that showed discrimination against Jake or attempts to remove him from my care. That's when I remembered I had my phone in my pocket during the entire conversation at Mark's house. I'd been so upset that I hadn't thought about it at the time, but I pulled out my phone and realized the voice recorder app was still running from when I'd used it earlier to record notes for my lesson plans. I played back the recording and could hear everything clearly. Lisa suggesting foster care, Mark talking about Jake being a financial burden, both of them discussing how to simplify the inheritance by removing Jake from the equation. Mr. Henderson listened to the whole thing and said this was exactly the kind of evidence that would be crucial if they challenged Jake's inheritance rights. He explained that the recording showed clear discrimination against Jake based on his disability and demonstrated that my siblings were more interested in accessing his trust fund than protecting his welfare. Mr. Henderson said this would be powerful evidence if we ended up in probate court, especially since my parents had specifically anticipated this kind of attitude in their trust documents. Mr. Henderson advised me to avoid discussing the trust details with Mark and Lisa until we had a better sense of their intentions. He said once they learned about the $400,000 trust plus the rental property, they'd probably escalate their efforts to gain control over Jake's care and finances. I asked what I should do if they continued pressuring me about foster care or tried to involve social services. Mr. Henderson said to document everything and contact him immediately if they took any legal action. He also suggested I gather Jake's medical records and school reports to demonstrate that he was thriving in my care and didn't need alternative placement. Before I left, Mr. Henderson gave me copies of all the trust documents and my parents' letter explaining their reasoning. He said these papers proved that my parents had carefully considered Jake's needs and had specifically chosen me as the person they trusted to manage his care and inheritance. About a week later, Mark called and said he and Lisa wanted to have another family meeting to finish discussing the estate. He suggested we meet at Lisa's house this time and said they'd already spoken with Mr. Henderson about scheduling. I agreed, but decided to record the conversation again since the last recording had been so useful. When I arrived at Lisa's house, both she and Mark were already there with notebooks and what looked like printed research materials. Lisa offered me coffee, but her tone was fake-friendly in a way that put me on edge immediately. Mark said they'd been doing some thinking since our last conversation and wanted to present some options for Jake's care. Lisa pulled out a folder and said they'd researched several excellent residential facilities that specialized in autism care. She showed me brochures for places that looked more like institutions than homes and started talking about the professional staff and structured programs Jake would have access to. I told them again that Jake was staying with me and I wasn't interested in residential placement. Mark said they understood my emotional attachment, but that I needed to think about Jake's long-term development and what would really be best for him as he got older. That's when Lisa dropped the real bomb. She said they'd been talking to people about my situation and had learned that single parents often struggled with special needs children, especially when financial stress was involved. She said they'd contacted Child Protective Services to get information about support services and had mentioned some concerns about Jake's care situation. I asked what kind of concerns they'd mentioned, and Mark said they'd explained that I was overwhelmed as a single parent and that Jake might benefit from more structured care. Lisa added that they'd told CPS about the inheritance situation and how the financial stress might affect my ability to make good decisions about Jake's needs. I realized they'd actually called CPS on me and tried to create a case for removing Jake from my care. I asked if they'd filed an official report, and Lisa said they'd just had an informational conversation about available resources. But the way Mark was avoiding eye contact made me think there was more to it than that. Mark said they weren't trying to cause problems, but that someone needed to advocate for Jake's best interests. He said if I wasn't willing to consider better care options, then maybe other people needed to get involved to make sure Jake's needs were being met. Lisa said they'd also spoken with a family law attorney about guardianship options in case I became unable to care for Jake properly. She said the attorney had explained how family members could petition for custody if there were concerns about a child's welfare, especially when substantial inheritance money was involved. That's when I understood their real plan. They weren't just suggesting foster care. They were actively working to have Jake removed from my care so they could control his inheritance. They'd called CPS to create documentation of concerns about my parenting, and they consulted a lawyer about taking custody themselves. I told them I knew about Jake's trust fund and that our parents had specifically set it up to protect him from exactly this kind of situation. Mark's face changed completely, and he asked what I meant about a trust fund. Lisa demanded to know what I was talking about and why this was the first time they were hearing about it. I explained that our parents had left Jake a substantial trust specifically for his care and that they'd made me the trustee because they trusted my judgment about his needs. Lisa got angry and said that wasn't fair since they were Jake's family too and should have input about how the money was used. Mark said if there really was a trust fund, then they definitely needed to be involved in managing it since I clearly wasn't equipped to handle that kind of financial responsibility along with Jake's care needs. He said they could provide oversight and make sure the money was being used appropriately for Jake's benefit. I told them the trust was irrevocable and that our parents had made their wishes very clear about Jake's care remaining with me. Lisa said they'd see about that and that no judge would allow someone like me to control that much money without proper oversight, especially when Jake's needs were so complex. A month later, we were all sitting in probate court while Judge Martinez reviewed the contested will. Mark and Lisa had hired a lawyer who was arguing that Jake's trust fund should be redistributed among all the heirs since he couldn't manage the money himself due to his autism. Their lawyer also claimed I was an unfit guardian who couldn't properly care for Jake's complex needs. Mr. Henderson had prepared extensively for this hearing and had organized all of our evidence, including Jake's medical records, school reports, and the recording from Mark's house. He'd also obtained the CPS report that my siblings had filed, which had been investigated and closed with no findings of neglect or abuse. The judge started by asking Mark and Lisa's lawyer to explain their objections to the will. Their lawyer argued that $400,000 plus a rental property was an excessive amount to leave to a disabled child who couldn't understand or manage such assets. He said the money would be better distributed among family members who could make responsible financial decisions. Their lawyer also claimed that I was overwhelmed as a single parent and that Jake would benefit from care provided by his aunt and uncle who had more resources and stability. He presented the CPS report as evidence that there were legitimate concerns about Jake's current living situation. Mr. Henderson stood up and asked permission to present evidence about my siblings' true motivations. He played the recording from Mark's house where Lisa had suggested putting Jake in foster care, and both siblings had discussed him as a financial burden that needed to be eliminated from the inheritance equation. Judge Martinez listened to the entire recording and asked Mark and Lisa if they wanted to respond to what they'd heard. Lisa tried to claim they'd been taken out of context and were just exploring all options for Jake's care. Mark said they'd been having a private family discussion about difficult decisions and hadn't meant anything malicious. Mr. Henderson then presented my parents' letter explaining exactly why they'd created Jake's trust fund. The letter specifically mentioned their concerns about Mark and Lisa's attitudes toward Jake and their desire to protect him from family members who didn't understand or value his needs. Judge Martinez read the letter aloud and asked Mark and Lisa's lawyer if he had any response to the parents' stated intentions. Their lawyer argued that the parents couldn't have anticipated how much care Jake would need or how the inheritance situation would affect family dynamics. Mr. Henderson presented Jake's medical records showing that his autism was mild and that he was thriving academically and socially with appropriate support. He also presented reports from Jake's teachers and doctors confirming that he was well cared for and developing normally within his abilities. The judge asked about the CPS investigation, and Mr. Henderson explained that the report had been filed by Mark and Lisa, not by any outside party with legitimate concerns. He said the investigation had found no evidence of neglect or inadequate care, and that CPS had closed the case without any recommended interventions. Judge Martinez asked Mark and Lisa directly why they thought Jake would be better off in their care rather than with his father. Lisa said they had more financial resources and could provide additional support services. Mark said they were concerned about my ability to handle both parenting and managing a large trust fund. Mr. Henderson asked permission to call me as a witness, and I explained how I'd been raising Jake successfully for 5 years since his mother's death. I described his daily routine, his progress in school, and his close relationships with teachers and neighbors who supported our family. Judge Martinez asked me about my siblings' suggestion that Jake would benefit from residential care. I explained that Jake thrived on routine and familiar relationships, and that removing him from his home and school would be traumatic and counterproductive to his development. The judge took a short recess to review all the evidence and returned with his decision. He said the parents' will was clear and legally valid, and that their stated reasons for creating Jake's trust fund were both reasonable and prescient given the evidence presented. Judge Martinez said the recording demonstrated that Mark and Lisa viewed Jake primarily as an obstacle to their inheritance rather than as a family member deserving protection and care. He said their decision to file a CPS report appeared to be motivated by financial interests rather than genuine concern for Jake's welfare. Epilogue asterisk. That was 6 months ago, and Jake's trust fund is now fully protected and managed according to our parents' wishes. Mark and Lisa haven't spoken to me since the court hearing, which honestly has made our lives much more peaceful. Jake doesn't really understand what happened, but he's noticed that we don't see his aunt and uncle anymore. The CPS investigation actually ended up being helpful because it created official documentation that Jake is thriving in my care. The social worker who handled our case said it was obvious that Jake was happy, healthy, and well-supported, and she couldn't understand why anyone had raised concerns about his living situation. Jake's doing great in school, and his teachers continue to report that he's meeting all his developmental milestones. The trust fund means I don't have to worry about affording his future needs like college, job training, or independent living support when he's older. My parents really thought of everything when they set this up. I've learned a lot about family loyalty and what really matters when money gets involved. It's heartbreaking that my siblings were willing to traumatize my son and destroy our family relationships over inheritance money, but I'm grateful my parents saw this coming and protected Jake from their greed. Mrs. Patterson still helps out with Jake sometimes, and she always says my parents would be proud of how things turned out. Jake has a secure future, he's surrounded by people who love him for who he is, and he'll never have to worry about family members trying to control his life because of his autism.